Hey, everybody, and welcome to the webinar. We have almost 1,000 folks registered today, so we want to give it a moment to let everybody come in because Zoom sometimes takes a minute to let everybody in from the waiting room or wherever you are out in cyberland before the webinar begins. So I'm Courtney Bullard, and I'm here with Stephen Richard. You'll also see Betsy Smith out there as well, and I'll talk a little bit more about that in a second. But as you come in, we would love for you to say hello in the chat bar and the temperature where you're located. So we know it is really cold across the country and a lot of places that are not used to the cold, like where we are here in the South. Some of you hopefully have some nice weather, like Chris from our team, bragging over there at 72 degrees. And also just want to say, for those of you joining us who have been impacted by the fires in California, we hope you're safe and well and hanging in there, and our thoughts have been with you. So again, we have almost 1,000 folks that registered for this webinar, not all of who will come live. So the chat bar, if you decide to participate, is going to go really fast. But folks are starting to add in where they're located and their temperature, so you can say hello to each other before we get going. This is also a webinar that is a combined K-12 and higher ed. You're going to hear me and Stephen go through some cases applicable to both. We'll call out some that might be more focused for higher ed versus K-12. So I wanted to point that out as well. And this is our, ICS's either 7th or 8th year-end review. And I always don't know whether to call it a year-end review or a year-in review. Maybe we'll change it next year. And my 3rd year having Stephen join me, which is amazing. So if you've been with us from the beginning, the very first time I did one of these webinars, welcome back. And if you're brand new, we love having you. So as I mentioned, I am Courtney Bullard. I'm the founder and CEO of Institutional Compliance Solutions. And I am thrilled to be joined by Stephen Richard, who's a partner at Nixon Peabody. He is a litigator, which is why I love having him come to talk about some of the applicable cases that happened or important cases that happened in this past year that impact the work that we do now and going forward. And it's a huge lift off of me because he's in the trenches doing the work every day. So he's a colleague and a friend. If you are not familiar with him and his firm or myself and the company, you can find out more about us online. I don't want to take too much time with those introductions because we have a lot to cover in our time together. All right, so the plan for our time together for this webinar. I'm going to cover the now vacated 2024 regs and kind of what's happened there, as well as what's happened from the Office for Civil Rights and resolution agreements and some things we can take away as we go into this year. And then I'll turn it over to Stephen, who's going to talk through some litigation trends and what we see happening in the courts. I don't know whether the webinar is going to be 45 minutes or an hour and 15 minutes, probably, hopefully right about at an hour, but we are recording. So if you need to jump off early, we understand. Do what you need to do. You will get a copy of the recording of this webinar and a Google Drive link with all the materials about an hour after the webinar ends. And want to say a special hello if you're listening to the webinar after the fact and you weren't able to join us live. So again, you will get the slides. I also put in there some of the resolution agreements I'm going to talk about and some other things that might be of interest if you want them to be able to access easily. And then the recording, again, will come about an hour after the webinar ends. We are doing an overview. Even in the last 24 hours, a lot has happened. And so we are feverishly trying to keep up with this ever-changing landscape. We are providing you with kind of high-level overview of things that we feel are important. There are some of you on here who might say, well, you didn't talk about this or that. So I always like to give that caveat, but we hope to cover quite a bit and maybe some things that you hadn't even considered that happened this past year. We're in a virtual environment. It is a great environment, but not always perfect. If something crazy happens and we go away, we'll get this recorded and back out to you. So just wanted to put that out there. And then lastly, Stephen and I are both practicing lawyers. but this webinar is not legal advice. You will see Betsy Smith on the team, my Chief Innovation Officer, is out there manning the chat bar. So if questions come in, she's going to be answering those for you to the best of our ability. But don't be surprised if a lot of your questions are answered by us saying, talk to counsel. I think now more than ever, talking to your legal counsel, if it's not us, is going to be really important as we navigate all that's happening. So I think that covers all of our overview. I want to make sure, Betsy, we're good out there in IT land. If you're just joining us, feel free to say where you're located and the temperature where you are right now, and we'll get going into the substance of what we're going to cover today. So, of course, the headline for 2024, I would say, was the release of the 2024 Title IX regulations with an implementation deadline of August 1st. So those came out in the spring, and then quickly thereafter, we had a lot of litigation that resulted in the 2024 regulations being enjoined from going into effect in August 1st in a lot of different states. So I'm not going to cover every single one because at this point it doesn't matter based on what happened last week. But the ultimate result was a 26-24 state split, with some of us going into August 1st of 2024 under the 2020 regulations and some of us under the 2024 regulations. Some of you were impacted by a ruling that came out of Kansas. And so maybe you were in a quote unquote 2024 state, but you stayed under the 2020 regs. But the bottom line is we kind of had a patchwork quilt out there. And so some of you are coming into the webinar today, fine, because you've been under the 2020 regs, and others of you might be feeling a little bit like my next slide. So on January 9th, shortly after Stephen and I had fully prepped for this webinar, a ruling came down out of Kentucky in a case called Tennessee v. Cardona, and the 2024 regs were vacated. Now, as somebody who has a law degree but does not litigate on a daily basis, it took a minute for us to realize that this decision actually got rid of the 2024 regs completely in all states. So our team was going back and forth. I was emailing Stephen. We're all working and trying to read this decision. But at the end of the day, for those of you who are under the now vacated 2024 rules, you might be feeling a little bit like Ross here from Friends, where you're like, what in the world, all that work? Now, we went into 2025 expecting the 2024 regs to go away. I think what we didn't expect was how quickly, and the when and the how. So when it occurred, as quickly as it occurred, and then the how it occurred through this court decision, I don't think any of us were quite expecting. We thought maybe it would happen a little bit later in the year. So on the 9th of January, we have the state of Tennessee versus Cardona. Again, Kentucky court decision, district court decision. And they held, the judge held that the 2024 rules exceeded the Department of Education's authority under Title IX, violated the Constitution, and are the result of arbitrary and capricious agency action. So as I said, that means they went away across the country. The Department of Education released a document shortly thereafter acknowledging this ruling. So saying on January 9th, a federal district court issued a decision vacating the final rule, the 2024 final rule, and consistent with the court's order, the 2024 Title IX regulations and some resources are not effective in any jurisdiction. So the resources listed are pretty much all the resources except one that I'm going to touch on in a minute. So everything dealing with the 2024 regs was gone as far as guidance and resources from the Department of Education, Office for Civil Rights, and everyone is now back to the 2020 regulations. Another thing I just want to note that came out in this document from the Department of Education, or that didn't come out, was any kind of guidance about open cases that are happening right now, things like that. So our team at ICS was on a retreat last week, which was awesome, down in Florida. And we had a long talk about what all this means. And then we're supporting a lot of schools and institutions as interim Title IX coordinators who were under the 2024 regulations. So Betsy came up with, I call it a matrix, kind of a step-by-step resource on what to do now, what to do here soon, and then what could maybe wait until the beginning of the school year. So if you would like a copy of that, when you get the recording and the materials, let us know and we will send it to you. If you're an ICS community partner, you're going to get that as part of your resources, as well as a big video that Betsy's going to do, breaking down a whole lot of things to help you with the transition. But overarchingly, what are we supposed to be doing for my 2024 schools? Of course, consult with legal counsel. But the first thing you need to do is dust off your 2020 policies. Hopefully you had good policies in place, or you kept them in place as a result of needing to use them for any reports that came in before August 1st, when the 2024 regs went into effect. But you need to dust those off and get them re-implemented or implemented for the first time. This is something we need you to do now, not wait for a board meeting this summer. So if you need to call an emergency meeting or something like that, we're going to encourage you to do that. We also want you to reevaluate your Title IX team's composition. So if you are a school that went to single investigator model, or you went away from live hearings, this is especially going to be important. But we want you to reevaluate your team and then ensure that they are trained under the 2020 regulations before they take on a new matter. So that requirement for training was in 2020. We had requirements for training in 2024. So make sure you do that. If you're a community partner with us, it's pretty easy because you can just go onto your training platform and take the 2020 courses. And then we want you to consider how to handle open cases. So if you had a report that came in on January 7th, if you're in the middle of an investigation, that's an area where we're providing guidance to our schools that we support. But you're going to want to talk to counsel. And if for all of our Title IX coordinators on here, you really need to sit down and evaluate what open cases you have and where they are in the process, and then how to handle each one on a case-by-case basis, given this new decision and where we stand now. And then lastly, although this doesn't cover all the things, but broadly what I want to tell you is thinking about how you're going to communicate with your school community about this change. And I think that will look different for every former 2024 school, because some of you, we know because we did the training as coordinators, interim coordinators, just trained your faculty, staff, and students on requirements under 2024. Others hadn't yet. And so this is going to look different, whether it's an email blast, whether it's a video, a YouTube video from your Title IX coordinator talking about this change at a high level. You need to get the 2020 policies back out there into your community and let them know what's going on. So again, very high level of kind of what you should be doing now for our 2024 schools who have to transition back into the 2020 requirements. I will tell you, go ahead, Stephen.
If I could just add another communication aspect that's really key. If you have an open case, it's very important to communicate with the students' advisors about where the case will be going, particularly if both students, the complainant and respondent, have attorney advisors. They will have their legal interpretations as well. So the communications not only have to be community-wide about what you intend to do, how, both where you stand and prospectively, but in an open case, particularly with the student parties and the advisors themselves, the communication aspect is really key. And you also have to make sure it's prompt and equitable. What you're telling one side needs to be told to the other side. So that's a nuance that could be a little bit more complicating for schools if advisors are attorneys, because they, like Courtney and me, will have their interpretations, and we all need to be in sync.
100%. So as our coordinators are triaging open matters or reports maybe that just came in, evaluating your communication with the parties on what's going to happen going forward, and of course, including their advisors, is going to be really important. For some of our schools, You may not have had them with advisors through the investigation phase, and now we're going to have to switch for the decision making and all of that. So lots to think about, and I think the communication piece is so important. And you're going to hear me talk about care and support at the end, but not only to address the attorney advisors who are going to have their interpretations and their opinions on how things should proceed forward, but also for those students and so they know it, or employees, so they know what's going on. Thank you, Stephen, for that. Also, I know I have this person here that looks pretty stressed out on the slide. And one thing we've talked about and a specialist on our team brought up is it does feel like, I'm sure for many of you, a lot of work for nothing. What I will tell you is this is my silver lining of it all. If you were a 2024 school, or if you took the training in anticipation of becoming a school that had to comply with the 2024 regs, I promise it's not all for nothing. You're going to hear me talk about pregnancy and obligations under Title IX. That was heightened under the 2024 regs, but has always been there. And so there's a lot of things we learned in going through this process, and you're going to see our company put out a blog post on this that we can take with us as we proceed forward, even going back to the 2020 regs. So that's my silver lining moment. But I know, and we see you and we understand this is frustrating. It's happening quickly at the beginning of this year as we start off the semester. And so we get it. We totally get it. So what else has been happening, or what else happened this past year when it comes to sub-regulatory guidance or enforcement from the Office for Civil Rights or the Department of Justice? That's what I'm going to cover here next. As we always see with a change in administration, at the end is kind of a flurry of last-minute resources and resolution agreements that come from the Office for Civil Rights. And so I put some of these in your materials and wanted to address a few of them here before we get going. One is the 4-year retrospective report, and I'm going to read a few things from it for you in a minute. One on retaliation, one on resolving hostile environment under Title VI, which I'm going to quote from in a little while, another on NIL, and one on online or digital sexual harassment under the 2020 regulations, which I think is the only guidance now that exists after the Department of Education sort of drew back on all of that. I'll touch on the one on Title VI. The others I'm not going to get into. It is also possible some of these will go away quickly, who knows? But the report that I want to talk about briefly can be interesting for some of you. I would call it a brag book of sorts. It's pretty long, and it goes through kind of what the Office for Civil Rights did over the last 4 years. And I'm just going to quote for you kind of in their press release what they said. OCR had the most productive 4 years in history. And then they go on to say in these 4 years that they received the highest ever number of complaints per year, culminating in a 64% increase over the complaint volume that they received during the previous administration, achieved the second, third, and fourth highest numbers of resolutions per year in history. They initiated 129 proactive compliance reviews, devoted the most resources in history to addressing discrimination based on shared ancestry or ethnicity, which you're going to see that theme in just a moment that I'm going to go over, and published a record 64 policy resources, more than OCR has published under any administration. So that this document, while some of this is going to go away, it's I think interesting in that it has a summary of a lot of OCR cases in here that I re-reviewed last night, resolution agreements, I should say. So you might find it interesting. Of course, it covers some things that I'm not going to cover today. So in the next slide, we're going to go into what we saw in Title IX. And I guess I'll just go ahead and go there really quickly. What we saw in Title IX when it comes to resolution agreements out from the Office for Civil Rights. And I only have 2 slides on this, but I will tell you what I'm going to talk about is sexual harassment and also pregnancy discrimination and accommodations. But there is more in the 4-year review that OCR did, and of course more that we've seen in resolution agreements. There's one agreement in here that I'm not going over, which is with the school district where OCR resolved a complaint alleging the district discriminated on the basis of sex by failing to effectively accommodate the athletic interests and abilities of female students. So just a reminder, gender equity in athletics does fall under Title IX. I'm not going to get into that in a lot of detail. And then also there are some cases or resolution agreements in here with respect to discrimination based on sexual orientation and gender identity and sex characteristics. So yesterday, President Trump signed an executive order that states that it's the policy of the United States to recognize two sexes, male and female. And then it goes on to say sex is not a synonym for and does not include the concept of gender identity. So I'm not going to spend time talking through that. There was activity in that area, of course, over the last 4 years. And as Steve and I were talking about before we started today's webinar, we don't know what all this means. You know, this has wide-reaching implications. There's going to be challenges. I think Stephen said there already are with litigation, maybe, to some of these executive orders, including this one. But I would be remiss if I didn't address it and bring it up before we got into this section. Stephen, anything else that I should be saying on that?
Yeah, and first, I would encourage everyone to take the time to read the executive order, whether you agree with it or not. It's an important document to understand. And two aspects immediately jumped out at me. Number one, there's a preliminary laundry list of guidance documents that have been rescinded immediately. So to the extent you are looking at a document issued by the Biden administration or have other types of guidance documents that have guided you, you need to understand what remains in effect and what doesn't. But also, most importantly to me, is that the Trump administration in the executive order said pretty clearly and emphatically, we do not agree with the prior administration's interpretation of Bostock v. Clayton County, which was a Title VII case from the Supreme Court that defined sex, at least in the employment context, to include, you know, beyond biological sex and to impact transgender individuals as well and afford them protections under the law. The Trump administration has come straight out and said, we don't agree with that interpretation. We're seeing courts like the Kentucky court last week in vacating the Title IX regulations, taking that position, but there are precedents that are out there taking the opposite position, applying Bostock to Title IX. So I'll get into this a little bit in the litigation, but read the executive order, understand what remains in effect and what has been rescinded, and also watch how courts particularly coincide with the Trump administration or differ from the Trump administration in the definition of sex and whether or not it extends beyond biological definitions.
Yes, and Stephen, someone said that your volume might be low, so I might have you, is it fine for Betsy? Okay, maybe that's only for some folks. So a couple things that Stephen just noted. We put in the chat bar, one of our attendees put in the chat bar a link to the executive order. If you are friends, quote unquote, with me on LinkedIn or with Betsy or Stephen, we're also kind of keeping that up to date as well. So we'd encourage you to connect with us on LinkedIn so you can find it. But we did put the link in the chat bar. Stephen, we'll have you speak up a little bit more. Some of our attendees are saying it's low. Others are saying you're good. So maybe speak up a little more when you get to your portion. And then you really need to talk to your counsel about the impact. We know there's conflicting state laws and everything else. So I just read this for the first time this morning. It just came out yesterday. A lot to discuss and to think about, but absolutely, please go read it. All right. So in Title IX, outside of that impact, what else have we seen? So I pulled this particular resolution agreement with respect to Title IX and a school district because we see this happening a lot when we're supporting school districts and institutions on the ground, but especially school districts. And that is not identifying conduct as Title IX and instead of classifying it in another area. So here, OCR found that the district failed to respond to notice that students were subjected to sexual harassment, and parents that were interviewed as part of the investigation had said they made reports, but they never heard back from the school. This is the part I want to highlight for you. Almost half of the bullying reports that were kept track of by the school included conduct that could constitute sexual harassment and should have been reported and responded to under Title IX. And there were some matters that might have been handled promptly, but under the wrong procedure. So the HR procedure instead of Title IX. And they pointed out that in that situation, then those parties didn't get some of the heightened really due process rights that come with the Title IX process as a result. We see this in higher ed on the HR side where things are misclassified or they're not bringing in the Title IX report. But in K-12, we see a lot of triage reports that are then put under as bullying. We also see, and there was a case that I don't have here, it's called Jane Doe or John Doe School District. They don't identify the name of the school district to protect the students, where a hazing incident, locker room behavior was classified as hazing and harassment, little h harassment, but not as sexual harassment. So we see that quite a bit as well. And I think given the focus of the new administration on due process rights, at least from 2020 and in the regs, we want to make sure that we're classifying things correctly when we're triaging as coordinators. It could be overlapping conduct, but certainly if there's a Title IX conduct, there are Title IX obligations that can be triggered. So there were other Title IX resolutions agreements that came out, but this is the one that I pulled out to highlight for our kind of shortened time here today. But in general, when you look at the resolution agreements, there's typically some pretty common themes that can be used as a blueprint for you as a school when you're going and evaluating, hey, where are we in our compliance efforts with Title IX? There's always a focus on remedies, at least with prior Office for Civil Rights over these last 4 years, both individual and then going back several years to reach out to complainants who they believe didn't receive the appropriate process, and then maybe some financial compensation or coverage. Requirements for climate surveys, robust record keeping. Typically, there hasn't been record keeping or very deficient record keeping according to the Office for Civil Rights. And asking schools or requiring schools to even look ahead. So maybe school year 21-22 is what is at issue. They're saying for future academic years, you also have to go and do an audit of your efforts to ensure you're staying in compliance. Of course, revised notices of non-discrimination and grievance procedures, always training. Almost every resolution agreement I've seen has training that needs to be happening for your Title IX staff. A lot of times they're saying annually, as well as when I say Title IX staff, I mean your Title IX team, as well as annual training for all staff, students, including an assessment for the effectiveness of the training. One note we've seen recently with the Office for Civil Rights, of course, it's going to look different going forward, is a training component that these schools are trained, their Title IX team is trained by someone who's done the work for 3 to 5 years. So that was interesting to me, and that's why you see that qualification there. Communication, we already talked about the communication piece in general with the transition for our 2024 schools. But in these resolution agreements, we see a requirement that the schools widely issue anti-harassment statements, including how to report, the role of the Title IX coordinator, supportive measures, resources. There's more to it than that, but that's kind of the long and short of it. And then monitoring by the Office for Civil Rights on all of these things, coming back and making sure that it's done. So wanted to note that also under Title IX is this prohibition on discrimination based on pregnancy and providing accommodations or modifications, as they were called, under the 2024 regs. So I pulled out this resolution agreement with Hines Community College. I think it's important for a couple reasons. Number one, what the Office for Civil Rights was reviewing was they were at the time they were under 2020 regulations. So with 2024 and the trainings we've done, of course, there's been this heightened focus on your obligations when it comes to pregnancy under Title IX, but it has always been there. And we've seen OCR agreement, resolution agreements I've covered last year and the year before on this same topic. So here the college failed to provide a pregnant student with necessary academic adjustments, or services during and after her pregnancy, and instead encouraged her to drop out of the program and complete it later. They also found some deficiencies, not some, a lot of deficiencies with how the college responded to the students' complaints of pregnancy discrimination and harassment. They did do an investigation, but the investigators were not trained on pregnancy specifically. So they were trained, as you might remember, under 2020, you have to post your training materials. So the Office of Civil Rights pulled those training materials. They had been trained on Title IX, but Title IX didn't encompass training on how to investigate these types of matters. And the other thing I thought is important to highlight, especially as everyone moves back to 2020 policies, is that the policy that they had was only related to sexual harassment. It did not encompass how to report if you were discriminated against based on pregnancy or to seek accommodations. It was just very sexual harassment focused. So as some of you have done revamped policies and procedures under 2024, there's some of that you're going to want to take with you back to 2020 policies. And I think this is a big area of that, which is ensuring it's very clear how somebody reports, how they go out and seek accommodations or modifications if they need them, that the Title IX coordinator oversees that. All those things still need to be part of your best practices in this area and are certainly part of those requirements. And again, I'm speaking very high level because I'm already well over my time and we have much more to cover. So, but really want to highlight that. All right, Title VI. So in the last days when we had a flurry of documents and resources released by the Office for Civil Rights, I think there was 8 resolution agreements with respect to Title VI and 1 with respect to Title IX. The numbers, when you look back at the resolution agreements, there's a lot on Title VI in this past year over Title IX, and you heard me refer to that in that look back manual or resource that OCR put out. They also put out the resource Resolving a Hostile Environment under Title VI that will be in your materials. But when we go train schools and institutions, a lot of times we are talking about Title IX, but we'll talk about overlapping protected class discrimination. And when we bring up Title VI, we kind of get blank stares. Like people don't always understand what it means. So I wanted to really quickly read from this resource. Title VI prohibits discrimination based on race, color, and national origin, including shared ancestry or ethnic characteristics, in the programs or activities of all recipients of federal financial assistance. These protections extend to students and school community members who share or are perceived to share ancestry or ethnic characteristics, including but not limited students who are Jewish, Israeli, Muslim, Arab, Sikh, South Asian, Hindu, or Palestinian. It goes on to talk about the existence of a hostile environment based on race, color, or national origin that is created, encouraged, accepted, tolerated, or left uncorrected by a school can constitute discrimination in violation of Title VI. And then it gives us the rubric the prior OCR used to determine if harassment creates a hostile environment under Title VI. And if you read it, it sounds similar to Title IX, 2024 regs, severe or pervasive. So I think this is a good place to start if you don't have a full understanding of Title VI and all that it covers, or if you just want to brush off in an understanding of that, that resource can be helpful. So I pulled a few resolution agreements, both in higher ed and in K-12 for different reasons. I'm only going to highlight a few of them as we go. The first one I wanted to highlight involved Muhlenberg College, and that's because the Office for Civil Rights actually pointed out some things that they did well with proactive measures that I thought was interesting, because we do have schools that are that have incidents and they're struggling with how to effectively respond and support students. And so what they said in this resolution agreement was that OCR recognized that the college had taken many steps to address incidents that may have created a hostile environment based on shared ancestry on campus, including through multiple community-wide emails from the President and Office of Religious and Spiritual Life. Dean of Students also wrote targeted emails to the Muslim, Palestinian, and Jewish identifying students to share ongoing support, care, and resources. Additionally, in response to specific concerns raised in several complaints, such as a complaint about doxing, the college developed brochures to distribute campus-wide to inform students about best practices for social media, doxing, protected speech, and harassment and discrimination. They also talked about how the policy that the college had in place, their non-discrimination policy, was actually good. It's just that they failed to abide by it in certain places. So there were some deficiencies that were found. So they go through in this resolution agreement their non-discrimination policy in a lot of detail. And we are helping a lot of schools put together policies that effectively address Title VI. And so I thought that was a good one to highlight for you. Also point out a few others. What I'll just say is that in the higher ed space, pre-OCR, we don't know what's coming next. A significant issue that they're identifying is premature classification of incidents as free speech rather than harassment. Now, that might all get flipped on its head going forward. It'll be interesting to see. But what OCR is saying is that you really need to have clear policies distinguishing between protected speech and harassment, and then need to assess the context and impact of these speech, as even protected speech can create a hostile environment if it targets individuals based on race, ethnicity, or national origin. So again, things are rapidly changing, but I wanted to point that out. Go ahead, Stephen.
Courtney, and just one other area to watch relating to free speech, bias incident response teams are a frequently litigated topic which have split the courts. Interestingly, there's a petition pending before the United States Supreme Court to review issues pertaining to constitutionality of responses by bias incident response teams. The case will be conferenced this week, I believe, with an order issued next week, whether or not the court will take it. The reason I highlighted it, this is not the first time that one of these bias incident response team cases has come before the Supreme Court as a potential case for review. Last time the court did not take it, but a few justices, particularly Justice Thomas, took the position that the court really should look into these teams and how they operate and whether or not they constitutionally adhere to free speech requirements. So watch carefully within the next week or so whether or not the Supreme Court takes the case to review the constitutionality of bias incident response teams.
Whew, I saw Betsy take a big sigh. There's so many things, I know, so many things to be thinking about. All right, just a few others I have in here that I'm just going to run through. I left them on here for you because, again, I think we're going to go to an hour and 15 probably of time, which is fine. Y'all hang with us, and you can always, if you need to leave, listen later. But of course, Title VI covers much more than shared ancestry. So we see this with race, national origin, and there's some key takeaways we see from all the resolution agreements in this space that are also highlighted in that resource. So again, if you are looking at your efforts in this area, this is a really good roadmap. What we see schools agreeing to is reviewing and revising policies and procedures. Training. So under 2020, you have required Title IX regs, you have required training that's required by law for anyone who's on your Title IX team, investigators, decision makers, all of that. What you see in these resolution agreements for Title VI is that they want your staff who are going to be doing the investigations to be trained. So we do civil rights investigator training for that very reason. It's training for students and staff, climate surveys, access to counseling and support for those impacted, anti-harassment education programs put on this by the school, and much, much more. So again, that resource that came out here not too long ago outlines and summarizes a lot of what we saw in those resolution agreements, and it's a really good roadmap as you kind of assess your own programs. Title VI does extend with national origin impacts language assistance. And so I threw this in here for our K-12. We have a lot of schools with hundreds of different languages that are spoken. So this might be one you want to take a look at, but in the interest of time, I'm going to keep on going. And then also, we just want you to remember ADA and 504 compliance. This is a slide from our civil rights investigator training that's been tweaked a little for this webinar. It goes beyond what happened in 2024, but we don't want to lose sight of that as well. I always say Title IX and related laws and regulations is the work that we do, and we're about 50% Title IX at this point as a company, and 50% 6 and 7 and all of that. Before I turn it over to Stephen, for my higher ed folks, really important, we also had a Clery amendment, Stop Campus Hazing, that was enacted on December 23rd. This is specific to higher ed, but we have some school districts where Clery applies because you have vocational or technical schools that fall under that definition. So for most of you K-12ers, you can tune this out, but some might want to pay attention. There are some fast approaching changes as a result of this, which include collecting statistics for hazing incidents and disclosing them in your annual security reports, adding statements to your policies related to hazing in your annual security reports, and developing a campus hazing transparency report. Here is a rundown of timelines for compliance. Some has already started, which is begin collecting stats. And I did want to note for you all that the civil penalty for violating Clery, which is now the Jean Clery Safety Act, has increased from 69,700-ish to 71,500-ish per violation. So that's continuing to increase. We will have much more on this. We're going to be doing more trainings in this area, but certainly another area that overlaps with Title IX that you all need to be starting work on now as an institution. Okay, we flew through a lot. I know there's questions in the chat bar that we'll get to at the end briefly if we don't cover them in the chat bar, but Stephen has, we will not get to them at all, Betsy says. Stephen has a ton to cover, so I want to make sure to give him the floor. And then Stephen, just if you'll be sure to speak up, that would be great.
Okay, so I'll speak loudly and hopefully everyone can hear me clearly. Let me just start with a caveat. As I go through cases, some of these cases are decided at the motion to dismiss stage where allegations are accepted as true, or at the summary judgment stages where inferences are given to certain parties. So some of the underlying facts may not be the ultimate facts as we learn in litigation. And also to the extent I may touch on one of your schools in a decision, that is not in any way meant to imply any wrongdoing, because as I said, these cases typically are decided in context pre-trial based upon presumptions. And I just wanted to give that caveat as I start to go through the various slides. So next slide, please. So Title IX, as you know, is a statute that is short in length, but big in impact. And the express means of enforcing Title IX under the statute is administrative enforcement through the Department of Education primarily. It's really fascinating that we have so much litigation, but so few in decisions from our United States Supreme Court. The Supreme Court recently touched on the then in place 2024 regulations in response to the various injunctions that had been issued. And the Supreme Court took a very broad view to say that those injunctions were enforceable because the court clearly signaled that it had multiple concerns about the provisions within them. Now, that all may become moot under the new administration, but certainly that's a signal as to where this court interprets Title IX. We did expect that the court potentially could take one Title IX case last year that came up for a potential appellate review out of the Ninth Circuit, Brown v. Arizona. Real important issue there dealing with when a school or a college or university can be held responsible under Title IX for off-campus conduct beyond the schoolhouse gates. The Ninth Circuit split in its various rulings, but essentially the key issue is under the Davis decision, which is still the controlling decision from the Supreme Court dating back to 1998-99 time period that talks about control over the harasser and the context in which the harassment occurs. Now, control over the harasser is generally easy to show. You have conduct policies. My college clients have policies that apply conduct expectations beyond the campus boundaries. But what does it mean to have control over the context in which the harassment occurs when you're dealing with off-campus assemblies, off-campus get-togethers? What about social media? Many of us expected the Supreme Court would take the time to use this split ruling out of the Ninth Circuit to give us an update on the important standards to apply in these vexing considerations. And the court issued its typical one-line denial, cert denied, and we don't have any further guidance. One other point to mention very briefly and importantly, you may have heard last year that the court issued the Loper-Bright decision, which deals with the degree of judicial deference that has to be given to an administrative regulation. Previously, there was a case called Chevron in which the court held for a long period of time that judges really should defer to the administrative body in the interpretation of a set of guidelines and requirements unless the statute was absolutely clear. And what Loper-Bright said with this conservative Supreme Court that we have now and for the foreseeable future is, we as judges will not abdicate our role in interpreting the law. So as we move forward with the Department of Education and challenges in court, the Loper-Bright standard of review will be very important. And I just wanted to highlight that because you may hear of that in the news and as matters evolve, both administratively and before the courts. Next slide, please. So I mentioned the case of Davis, and there's another case called Gebser v. Lago Vista School District. And both of these cases are now 25 years old. They deal with the standards by which a school or college or university can be held responsible for either faculty on student sexual harassment, which is Gebser, or peer student on student sexual harassment, which is Davis. These cases make clear that the school has to have certain signals, actual notice. It has to respond a certain way, which is essentially an intentional way with deliberate indifference. But the devil's always in the details. And we see a lot of cases varying about whether or not a school has actual notice of alleged harassment and how, and whether or not a school's response was deliberately indifferent or maybe just sloppy. There's a difference in the standard. Sloppiness is not deliberate indifference. But I did want to highlight one case that really caught my interest, and it came out of a college context, but it has a lot of applicability, obviously, to K through 12, and unfortunately, too often to all of our schools. The issue of grooming. I have defended a few cases in which schools have been sued for alleged grooming behaviors by faculty or athletic trainers, whoever it may be. And the signals of grooming behavior are often very difficult to catch. It can be something as general as flattery, over attention to a student, things that are not openly sexual in nature that could compile to such an extent that there are sufficient red flags that that grooming behavior should tip the scales and constitute actual notice requiring a school to respond. So I just wanted to highlight that it's not as simple and straightforward as seeing what you see and saying it's sexual harassment. It's really important for all official decision makers, persons who are authorized to take action, and mandatory reporters to keep their eyes and ears open. Next slide, please. So what causation must be shown? Okay, that we talked about a school having to have actual notice. You have to know what's going on. It's not constructive notice. It's actual notice to be held liable under Title IX. Your response cannot be deliberately indifferent, which means it cannot be clearly unreasonable in light of all the known circumstances. But what else has to be shown? Is it sufficient to say that a single incident that put the school on notice without any subsequent occurrences is enough to avoid liability? And this is where it gets really unclear under Davis, and the court has had the chance to clarify this language and has not yet done so. But what Davis particularly says in the context of student-on-student harassment is that the school's response, if deliberately indifferent, must cause the student to be subjected to sexual harassment, namely causing the student to be subjected to further harassment, or leave the student vulnerable to it. What does that mean? And that issue of vulnerability, again, is a very vexing consideration that courts grapple with. I have cases in which complainants will sue the school saying, you left the respondent on campus. You left me vulnerable to further harassment, even if it didn't occur. I wouldn't go to certain parts of the campus or the school. I missed certain classes. And this is where documentation is really important in defending your case. You can't guarantee against all interactions or occurrences, but if you have no contact orders, make sure you document and detail your enforcement and maintenance of them. Make sure that this is a continually evolving situation, whether in K-12, we are trying to separate two students, perhaps in the same building, or in the higher ed setting where you have perhaps more leeway, but still need to separate students on campus or even off campus. I always tell my clients that deliberate indifference is a continuous standard of review, that it's not a snapshot. So do not sit on your laurels to say, we've established the peace. You need to continuously look at the effectiveness of your measures and tweak and adjust them as may be necessary, because that issue of leaving a student potentially vulnerable to further harassment could be a liability hook that can create major problems in litigation. In the K through 12 area, courts are more particularly focused on holding the schools responsible and are more inclined to find that a single incident of sexual harassment is enough. So know your jurisdiction. Also, in the faculty on student context, understandably, courts are a little less receptive to the argument that nothing else happened. Once is often too many times in a faculty on student situation. So bottom line here is, do not rest on your laurels. Even if you think your measures are working at the time you are evaluating them, it is a continual process that has to be implemented to avoid liability. Next slide, please. Trends in respondent lawsuits. I mean, we saw a lot of pendulums shifting with the Obama administration's documents that many respondents felt were draconian to their defenses, lacking due process, and certainly making it difficult for a respondent to address his or her positions and perhaps prove their innocence. We've seen courts try to grapple with guidelines and how to assess the standard of review in litigation when a respondent sues a school to say the process was unfair. There are established standards that have been in place for a while. Erroneous outcome, meaning that the wrong decision was reached and it was motivated by gender bias, or selective enforcement, that you choose to, for example, proceed with cases against males more frequently than you do against females, or you punish males more severely than you do females, or vice versa, depending on the statistics and trends. But what we're seeing more often is courts asking a more basic question. Do the facts and circumstances suggest that gender was a consideration in the process? And looking at things like the frequency of procedural errors, deviation from policies and procedures, even if minimal, a compilation of them can be problematic. Certainly, statements that people should or should not make. I will be, very blunt here. Tell your folks to be careful what they put in emails when they are drafting decisions, to try to limit the number of actual drafts and how you proliferate drafts, because those can all be discoverable. So we are seeing a more broadly based view of how do you assess whether or not a respondent received a fair process, and a more global and holistic consideration of what could potentially involve gender bias. And I mentioned, a Second Circuit case that has been coming up more frequently, where courts are now saying that if there's indicia of a sham process, and how do you define a sham process? And it's easy to do that retroactively, but all of this can equate to a finding of gender bias, and respondents are increasingly focusing on nuances like a multitude of procedural errors or statements external pressures, all of which can be problematic in defending the fairness of your process. And finally, obviously for public schools and public universities and colleges, there are constitutional due process requirements that apply as well. Next slide, please. And this is the Second Circuit case that I just mentioned. It's really interesting because the court sort of looks at this with 20/20 hindsight, which is the way I, perhaps with a bit of a bias, interpret it. But the court said that we're going to look at whether or not the sham process equates to deliberate indifference. Now, remember, I told you deliberate indifference is a standard of review on the complainant side. When a complainant brings forth an allegation that I've been sexually harassed or assaulted, I've notified you as my school, you need to take responsive action, and that responsive action cannot be deliberately indifferent. This Second Circuit case sort of turns this analysis onto the respondent side and says, does the school proceed in a manner that was not, did the school proceed in a manner that was not deliberately indifferent to its policies and procedures? So what you really need to do is carefully train your folks, as Courtney said, but in the implementation, make sure that you are adhering to your policies step by step, communicating in a consistent way. I can tell you in a lot of my cases, I have different level of interactions by advisors. Some advisors are very proactive in contacting the Title IX coordinator. Others are more passive in doing so. You really need to make sure that those communications are balanced and equal. What you're saying to one party, you're saying to the other, because all of this is discoverable in litigation. In a case such as this in the Second Circuit, taking a more expansive view of how you can be held liable for a process is really a trend that I think we're going to see more of with the shift back to the 20/20 regulations by the Trump administration, and that filtering into the courtroom process even more. That respondents are going to say that due process is a holistic analysis, and you're really going to, like the first slide, putting together a jigsaw puzzle, piece it together piece by piece to paint the picture of compliance. Now, having said that, I want to say that I'm not trying to sound like Chicken Little telling you the sky is falling. I always tell judges that perfection is not the standard when it comes to implementation of policies and procedures. But you do need to ensure the court that you've done so in a neutral way that's prompt and equitable. So please do not think that if there's a mistake in the process, it's fatal, but remedy the mistakes, learn from the mistakes, and prevent their reoccurrence. Next slide. Key issue that's really been evolving in the court, Title IX retaliation claims. Just don't think of this as obviously a reporting of sexual harassment and how you proceed vis-a-vis the complainant and the respondent. But we do increasingly see claims of retaliation that can take two components. One is an allegation that the school itself retaliated against me for engaging in protected activity. I filed a complaint and the school retaliated against me for doing so. But where it really gets interesting and where the claims are evolving are situations where there's retaliation, perhaps students saying something to a complainant or respondent that creates a retaliatory environment. And how are schools supposed to respond to that? And what some schools initially would say in their defense is, no, we weren't the retaliator, therefore we should not be held responsible. What the courts are looking at now is, was your response deliberately indifferent to the retaliation? So I talked about deliberate indifference and making sure that your response was not clearly unreasonable when it comes to how you handle and process and decide a complaint, but also how you resolve the interactions between students, particularly keep the peace within your school or within your campus as the cases evolve are just as important. And just do not dismiss someone coming forward and saying to you that, all these students are saying this about me in the dormitory, or all the respondent or complainant's friends are accusing me of this or that. It could reach the level of retaliation in which the school can be held responsible for its response to third-party conduct. So it's not only your own individual retaliation that you have to defend against, but how you respond to retaliation and such conduct by third parties within your programs and activities. Next slide, please. This is a big area. Obviously, Title IX does not pertain only to students. The statutory language of Title IX at 20 U.S.C. Section 1681A starts by saying no person in the United States. It does not say no student. So person obviously can equate a body of individuals beyond your students. And we have seen courts grapple with how do we apply, if at all, Title IX to employment cases, because we have a traditional body of employment law cases, Title VII of the Civil Rights Act of 1964 at the federal level. There are a lot of state laws that pertain to employment. And Title IX was a spending clause statute, a contract between the government funding agencies and the recipients not to discriminate on the basis of sex. And we have seen courts split to say the statute says no person. Person is broader than a student. Therefore, Title IX can cover employment claims. Now, for a while, the Fifth and the Seventh Circuits were the outliers, saying, no, we don't think that Title IX was intended for this purpose. And for a while, it seemed like the pendulum was shifting towards expanding Title IX across the courts to include employment claims, until recently when the 11th Circuit spoke and took its view that we do not think that Title IX was intended to apply to employment claims. Particularly, the court took a look at the legislative history of Title IX and its purpose and came to the conclusion that we agree with the Fifth and the Seventh Circuits that Title IX is a discrete, sort of narrow statute that does not have a broader applicability to employees. Now, this is an issue that may reach the Supreme Court because for the longest time, we assumed that those two courts, the Fifth and the Seventh Circuits, were outliers. They were older decisions. We now have the 11th Circuit joining in saying, we agree with the Fifth and the Seventh. So we have a real right circuit split that could reach the Supreme Court's attention. Why is it important? Well, for a couple of reasons. Number one, Title IX is a statute that does not have to go through administrative process like a Title VII claim, which has to go before the EEOC. So it's easier to just file a lawsuit under Title IX. Title IX does not have a statute of limitations expressly. Title VII does, generally, 300 days under Title VII, and state laws a year or so. But the employment statutes generally have a very finite limitations period. Title VII claims borrow from state statutes, and particularly state personal injury statutes, and equate those personal injury statute limitations periods to Title IX. So, for example, in my jurisdiction, that's 3 years. So an employment case could be arguably time barred under Title VII, but still ripe under Title IX. Another significant consideration. Title IX does not have limitations per se on damages. Now, the Supreme Court has applied some, but Title VII does. So there are significant differences between the two, and whether Title IX will in fact extend to employment claims, maybe a continuing dispute amongst the lower courts, or the Supreme Court may weigh in. Next slide. And I talked about damages recoverable in a Title IX claim, and we covered the Cummings case last year, which was really significant. Title IX is a particular statute enacted under the spending clause of the Constitution, whereby, as I said, it's a contractual arrangement between a federal funding agency, the Department of Education, and the recipient of federal funding, your school district, your college, or university. And what the court said in Cummings, the United States Supreme Court, is that we will apply to Title IX traditional contract damage claims. And therefore, emotional injury damages, which are traditionally not recoverable under contract, should not be recoverable under a Title IX, under a spending clause statute. Now, the Supreme Court did not have a Title IX spending clause claim before it. There were other spending clause statutes that were at issue in Cummings, but courts have since routinely said that Cummings applies to Title IX. So as a Title IX defense attorney, I will often say to a court, read the complaint, Your Honor. They're pleading emotional injury damages, which are not recoverable under Title IX, and that aspect of the damage claim should be dismissed at the outset. I cite a case from my jurisdiction, Doe v. City of Pawtucket, which is a really good read to understand the scope of what this means, because it's not as simple as just saying emotional injury damages are not recoverable. Therefore, the scope of potential damages is pretty limited. Courts are grappling with, well, what about medical costs? What about if a medical cost is more related to a physical component of an injury than an emotional component of an injury? What about a PTSD claim? Does the post-traumatic stress syndrome equate to a physical injury, or is that a claim based on an emotional injury? So courts are really trying to define the scope of Title IX liability, which is important for all of you out there that are involved in risk management. Generally, medical expenses associated with physical harms are recoverable, and you really have to dig into the details of the records. But we're also seeing a lot of claims where complainants who are sexual assault victims or respondents who have been held responsible and had interruptions in education due to suspension or expulsion are bringing future damages claims. That not only do I want my present damages compensated, but because of what has happened to me emotionally or physically, or because of the fact that I've been thrown out of school, having been found responsible for sexual misconduct that I'm challenging in this lawsuit, I'm entitled to future damages. And these claims can be astronomical. I have seen them extend out potentially 10, 20, 30 years. Now, whether or not those are recoverable is a litigation battle, but that's the extent of claims that plaintiffs typically make. And courts are starting to pull back to say that, again, this is too speculative or too remote from the underlying conduct to hold schools responsible. But by no means is this a clearly established playing field. So again, for those of you in risk management, understand that the damage components of these claims, even after Cummings, is still undefined and uncertain in many respects. And you really need to keep your eyes on that as you try to value a case and determine whether or not to settle or to litigate. Next slide, please. We mentioned Title VI in Courtney's presentation, so I'll just go over this briefly, but Courtney read to you what Title VI entails. It's another spending clause statute, actually predating Title IX by 8 years. It was enacted in 1964 as part of the Civil Rights Act. But we're seeing post-October 7, 2023, a lot of lawsuits, a lot of class actions about conduct on campuses or within schools in response to the events in the Middle East, and obviously differing perspectives about political views. And it's really an area where you just don't want to watch OCR's response, and particularly how the new administration will respond and what happened under some of the resolution agreements that Courtney pointed out to you. But courts are increasingly seeing these claims. They are really at their nascent and beginning stages. We don't have a clearly defined body of case law just yet. And as we will see in the next slide, what we often encounter, this was fascinating. The same judge within 1 week heard Title VI claims against Harvard and MIT, both of which were presented at motions to dismiss at the pleading stage, very preliminary stage, where courts are highly deferential to cases and have to assume the truth of all well-pled allegations. The same judge ruled within 1 week that one case could not proceed past the pleadings, the other case could. Obviously dealing with highly charged and emotional issues that occurred on both of these campuses, but the judge felt that at least as pled, the MIT case showed, even accepting the truth of the allegations, a proactive, interactive, evolving response that Harvard, at least as alleged against Harvard, did not clearly evidence. And again, this was only on the pleading, so you have to accept what's pled. It may not have been consistent with what actually happened. But we as litigators deal with this reality, and this is just a prime example. Sometimes you have judges within the same court reaching different decisions, or different jurisdictions, as I showed with the employment Title IX claims, interpreting matters differently. But here, within 1 week, the same judge essentially interpreted very comparable cases differently. So pay careful attention to what's alleged. Work carefully with your attorney at the outset in your defenses. I often tell my clients that we have to think at the outset whether we want to move to dismiss, accepting the truth of the allegations, because sometimes bad facts as alleged, even if we don't believe they are in any way true or provable, can create bad law. Next slide. very briefly, an area to watch, and Courtney talked on this a little bit, athletics. Um, Courtney mentioned last week the Biden administration on the way out the door issued a fact sheet dealing with its Title IX interpretation as it applies to the ever-changing world of athletics, and particularly, athletic funding assistance or benefits and opportunities applied to athletes. The Biden administration took a very clear position that Title IX applies and that you need to ensure gender equity consistent with Title IX standards. That's particularly important to colleges and universities as the House NCAA settlement goes forward and monies have to be distributed. Some schools intended to direct the money to the big ticket programs like football and basketball, but that may not, at least in the Biden administration's former view, pass administrative muster. We're waiting to see what the Trump administration will do. Senator Cruz, who's a very conservative senator, as you know, but will be chairing the Senate Commerce Committee going forward, spoke very critically of what the Biden administration wrote last week. So we have to watch this very carefully to see how Title IX will apply to your athletic programs, particularly in gender equity and NIL opportunities for athletes, and also collectives, these third-party funders. Even if the school is directly not per se involved in all the details of the NIL arrangement, does the impact of what happens through NIL funding disparately impact genders within your athletic programs? Really evolving issue, obviously a lot of money at stake. One other area that I mentioned, and I put it in athletics, but it's across the board, but I'm seeing it more and more in athletics. Bullying has become a front and center issue in a lot of my cases. Courtney mentioned the Stop Hazing Act that was passed last week and its impact on colleges and universities, but we're seeing increased lawsuits and activities in bullying and hazing claims, so pay careful attention to them. And obviously the whole issue of transgender students, and here on the athletic slide, is a to be continued. As I said at the outset, the Trump administration made very clear yesterday that we will not enforce what the Biden administration articulated, and we do not interpret Bostock to apply to Title IX. Many courts have a differing viewpoint. We could be going on divergent views here, with courts going in one direction, depending on where you are. Some courts going in the same direction as the Trump administration, and ultimately it may make it to the Supreme Court, but we'll see, to be continued. Next slide. So that, in an overview, is a quick overview of litigation, recognizing we've tried to cover a lot and a lot of vexing issues in a short period of time. So I'm going to turn it back to Courtney to give you a bit of a roadmap going forward as we conclude our program.
Thank you, Stephen. Always so helpful to have you break down this complex stuff, especially with litigation. Even for lawyers, it's hard if you're not in the trenches every day. So I don't know if anybody is on social media and has seen this what's in and what's out for 2025 trend at the beginning of the year. So I kind of just did a quick roundup of everything we talked about today, and what's in and what's out for 2025. So what's in? Clery compliance, we call it. If you go watch Living Title IX with Betsy and her YouTube channel, she just did a whole thing that she put in the chat bar on this about Clery being about transparency. So that is definitely in. User-friendly policies, of course, that comply with 2020 Title IX regs. Title VI compliance, we still believe, is going to be a hot button issue. We always say at ICS, care and support. You heard it in some of OCR's resolution agreements, but care and support for your students and your community is going to be probably more important than ever as things just transition, and the unknown can be extremely stressful for those on the ground. Trauma-informed practices, as long as they're equitable, of course, are still around and here to stay. You heard me talk about pregnancy accommodations and modifications. Still something you should be focused on, even as you transition back to your 2020 policies, and that might need updating over the summer. And then informal resolution. So we've seen informal resolution used in Title VI, Title IX, Title VII. That is still absolutely here to stay in 2025. What is out? The 2024 regulations, as we talked about, non-compliance with the 2020 regs. So here's my moment. The 2020 regulations have been around now since 2020. So we're going into, I don't know, the 5th academic year next year with these regulations in place. So if you don't have a strong policy, if your folks aren't trained because you were under the vacated 2024 regs, now's the time to shore that all up. Not following policies and procedures, that's always been something that's out, but we want you to be sure that if you have a policy, you are following it from a litigation perspective and an OCR enforcement perspective. Websites that are not user-friendly and up-to-date. Hopefully, if you were under the vacated 2024 rules, you beefed up your websites because of some of the requirements to keep an eye on barriers to reporting. But we want that to stay. We need that Title IX coordinator front and center, how to make reports, and we need it to be user-friendly, both from your phone and online. Silos are out. We always have said at ICS they should be out, but you see all these overlapping areas: HR, student conduct, Title VI, Title IX. We want you to be collaborating across campus or across your community at school districts on these areas. We talk a lot about compliance. It's in the name of my company, but that really is the floor. We want your offices to be a place for care and support, whether in Title IX or other offices, and compliance being kind of your roadmap, but we want you to be leading with care and support, not with compliance. And then we didn't even get into all this, but DEI is out for 2025. So with that, so many things to talk about, but future trainings, we'd love to have you in them. I've put them here for you. You will get a follow-up email with a code for attending this webinar to get a discount on future trainings. And something that I'm really excited about is a symposium we're hosting. It is K-12 specific. However, we have a couple of higher ed folks that are registering, one outside of Nashville, Tennessee, and the other outside of Los Angeles, California. They're both hosted by school districts. We were in connection with our LA district last week to see how they're doing. We are planning to proceed forward. And please know, if you come, we're going to use any proceeds from that training and donate them to a local organization that is going to be supporting those who are impacted by the fire. So really excited. This is a first ever symposium that crosses over Title IX, mental health, and school safety. If you want to come in your higher ed, there's plenty of tidbits that you will come out of it and be able to use in the higher ed space as well. So just let us know. Great lineup of speakers and colleagues coming. We would love to have you there. So we have gone well over our hour, but I did say 45 minutes or an hour and 15 minutes. So we're not going to have time for questions, but I know that Betsy has been feverishly answering things in the chat bar. So hopefully you all have been able to get some of these questions answered. But if you need anything, we're here. You can find Stephen's contact information as well through our website or directly on his law firm's website. But we appreciate you hanging in there with us. We appreciate your work you're doing on the ground every day. We know it's a lot. We hope you're staying warm if you're in one of these really cold places right now. We hope you're safe, well, all the things, and to see you either at a training, in person at a symposium, or somewhere else out there in the world as we go through 2025. So with that, we will sign off. Thank you, Stephen. That was excellent. We appreciate you so much and our partnership with you. And you will get this recording and all the slides in about an hour. Thanks, everyone. All right, let me stop the webinar. There we go. Bye, everybody.